At 9 this morning, Mike Pence walked into the federal courthouse in Washington, D.C., carrying a leather folder and wearing a dark navy suit. Two private attorneys walked beside him. He did not speak. He did not wave. He did not acknowledge the cameras. 4 hours and 11 minutes later, at 1:11 p.m., he walked back out. Same posture, same silence, same expressionless face. And if what multiple sources are now describing is accurate, then inside that courthouse for 4 hours and 11 minutes, the former Vice President of the United States gave testimony that could become one of the most consequential pieces of evidence ever heard in a case involving a former president. Because this wasn't a political rival. This wasn't a hostile witness. This was the man who stood beside Donald Trump for 4 years, who heard the private conversations, who sat in the same meetings, and who lived through the exact moment the pressure campaign collided with the Constitution. And today, according to reporting from people familiar with the testimony, Pence didn't hedge. He didn't flirt with ambiguity. He didn't both sides it. He described the pressure, the asks, the tone, the intent. And then prosecutors played audio, an alleged phone call between Trump and Pence, that if authenticated and ultimately admitted at trial, is the kind of evidence that changes the geometry of a case. Not because it's dramatic, but because it's simple. And in court, simple beats clever. Here's what we know and what it could mean. At 1:34 p.m., the lead prosecutor delivered a short statement to the press. Quote, "Former Vice President Mike Pence testified today for approximately 4 hours. His testimony was complete and detailed. We have no further comment at this time." That's the sort of sentence prosecutors use when they believe the testimony speaks for itself. Then, at roughly 1:47 p.m., sources say the court heard a recording, previously unknown to the public, of a conversation between Trump and Pence. And the phrase being repeated by multiple reporters is striking, begging. In that recording, Trump's voice is described as saying, quote, "Mike, I am begging you. Please do not certify these votes. You can stop this. You have to stop this." If that audio exists, if it's authenticated, and if it's admissible, it matters for one reason above all others. It goes to intent. In cases like this, intent is the mountain prosecutors have to climb. It's not enough to show chaos happened. It's not enough to show pressure existed. It's not even enough to show an official act was targeted. They have to prove the defendant knew what he was doing and did it anyway. And the difference between "I believed I was right" and "I need you to do this for me" is the difference between a political argument and a criminal one. Now, before we go any further, there's a crucial point to make here, and I'm going to make it like an adult. Details being described right now are based on accounts from sources who say they were present, or briefed, or familiar with the testimony. Court proceedings can be sealed, recordings can be disputed, transcripts can be contested, and what gets talked about outside the courtroom is not automatically what gets admitted inside the courtroom. So we're going to analyze this the right way, carefully, precisely, and without turning our brains off. Because if this is real and it holds up, it's devastating. And if it's contested or excluded, that also tells you something about strategy, about risk, and about what each side fears most. So let's walk through how Pence even got to that witness chair in the first place. When Trump was indicted on charges connected to January 6th and the certification process, Pence was subpoenaed, and Pence resisted. Not because he didn't want to talk, at least not publicly. He resisted because he argued that on January 6th, his role as president of the Senate was essentially legislative in nature, and therefore protected under the speech or debate clause. That clause exists to protect Congress from intimidation by the executive branch or courts. It prevents lawmakers from being questioned about official legislative acts. Pence's argument was, on January 6th, I was presiding over a constitutional function inside the legislative process. You can't drag me in and interrogate that. A district court rejected that argument. He appealed. The D.C. Circuit rejected it again. And the Supreme Court, according to reporting, declined to take it. At that point, Pence's options collapsed into reality. So he negotiated. And that part matters more than people realize. Because when a witness negotiates scope, the prosecution isn't getting everything. They're getting something specific. The reported agreement here is that prosecutors would not question Pence about internal deliberations about electoral counting, meaning what he thought, what he weighed, what legal theories he considered as presiding officer. Instead, they could question him about conversations, pressure campaigns, and events he witnessed as vice president and participant, especially communications from Trump and Trump's allies aimed at influencing Pence's behavior. That's a surgical approach. And if prosecutors played a recording today, it suggests they weren't just collecting vibes, they were building a spine for the case. Now let's talk about what Pence is believed to have testified to. According to multiple sources familiar with the testimony, Pence described repeated contact from Trump in the days leading up to January 6th. Multiple calls, multiple asks, multiple attempts to reframe the vice president's authority into something it simply was not. Reject votes, delay certification, create a pretext, hand it to the states, anything that changes the outcome. And Pence, according to those sources, said he refused every time because he believed it was unconstitutional and illegal. That matters because it sets up a central conflict that the prosecution wants the jury to understand. This wasn't a misunderstanding. This wasn't confusion. This wasn't, we just needed to check. This was a pressure campaign aimed at forcing one official to do one thing, stop the certification. And that's where the recording becomes the nuclear core of this story. The recording, as described, is from January 5th, the day before certification, the day before the attack. Trump is described as saying things like, I am begging you. You can stop this. You have to stop this. And at one point, according to the accounts circulating, Trump leans into personal loyalty. I gave you this position. I need you to do this one thing for me. If that's accurate, it's not just a request. It's not even just pressure. It's a framing device where the office becomes a personal asset and the constitutional duty becomes a favor. And that's exactly the kind of framing jurors understand instinctively. Because jurors don't need to know every statute. They don't need to memorize constitutional commentary. They need to answer a human question. Was this person trying to do the right thing or trying to keep power? And I gave you this position doesn't sound like constitutional scholarship. It sounds like a boss reminding an employee who signed their paycheck. Now imagine this audio being played in court. Not a tweet, not a headline, not someone's interpretation. Trump's voice, the words, the tone, and then Pence, calm, controlled, responding, I can't do what you're asking. The vice president doesn't have that authority. I have to fulfill my constitutional duty. That contrast is a prosecutor's dream because it tells a story with roles. One man demanding, one man refusing, one man treating the Constitution like a doorstop, one man treating it like a lock. Now, the defense is going to do what defenses always do in cases like this. They will try to move the fight away from intent and into belief. They will argue that Trump believed the election was compromised, therefore he believed extraordinary action was justified, therefore he lacked criminal intent. But there's a problem with that strategy, one that becomes much worse if this recording is real. Even if someone believes something false, they can still knowingly commit obstruction. Belief doesn't automatically erase intent, because the law doesn't require prosecutors to prove Trump believed he lost. They have to prove he knowingly attempted to obstruct an official proceeding through unlawful means. And asking the vice president to do something you've been told he cannot do over and over by lawyers, advisors, and the vice president himself, that starts to look less like good faith confusion and more like desperation. And juries know the difference between confusion and desperation. Here's where Pence becomes a uniquely dangerous witness for Trump, because he is not easy to caricature. He's not a progressive activist. He's not a Democratic official. He's not a cable news personality. He is a conservative Republican who made his career inside the party Trump dominated. He ran for office. He ran for president. He knows the base, and he also knows what it costs politically to testify in a way that harms Trump. So when he speaks, he carries something valuable in court, perceived credibility. Not because he's perfect, not because jurors worship him, but because jurors understand incentives. And Pence's incentives are complicated. A witness who testifies against their own side often reads as reluctant but compelled, especially after a subpoena fight and failed privilege claims. That can make a jury lean in and listen. Now let's talk about what we're already seeing from Trump's response, because it's predictable and it matters. According to the script of modern Trump-era defense, the moment damaging evidence appears, you don't just dispute it. You delegitimize it. You say it's fake. You say it's a witch hunt. You say the witness is a traitor. You say the system is rigged. And that's what sources report Trump did. He attacked Pence personally, denied he begged, claimed the tape is fake, and threatened legal action. But here's the brutal truth. Calling something fake doesn't make it fake. In court, you don't win by posting. You win by proving. If the defense claims the recording is fabricated, they'll need to attack authentication. Where did it come from? How was it stored? Who had access? What's the chain of custody? What forensic analysis was performed? Did the court already rule on its admissibility? Because judges don't just let random audio play in a courtroom like it's a podcast. If it was played, there was a reason. Now, that doesn't mean the defense can't challenge it later. They can. But if they do, that process will reveal what each side has and what each side is afraid of. So here are the real next moves to watch. And I'm going to give them to you like a prosecutor would think about them. Indicator 1, motions to limit Pence. If the defense files motions to block parts of Pence's testimony, it means they believe specific statements are lethal. Indicator 2, the scope fight. If the defense argues prosecutors exceeded the agreed scope, meaning they pushed into speech or debate territory, then a judge may have to carve out what stays and what goes. Indicator 3, corroboration. If other witnesses, staffers, attorneys, Secret Service, White House aides confirm Pence's account, then Pence becomes the centerpiece of a mosaic, not a lone voice. Indicator 4, the origin of the recording. If the recording comes from official call logs, White House systems, or another credible source, it's extremely hard to dismiss. If it comes from a third party, the defense will try to create doubt. Indicator 5, jury impact. If jurors took notes aggressively during the recording, that's not a sign of interest. It's a sign of this matters. Indicator 6, defense strategy shift. If the defense stops focusing on law and starts focusing on character assassination, Pence is bitter. Pence wants a book deal. Pence is saving his reputation. It's because the facts are heavy. Now let's frame 3 possible outcomes, because this is how serious legal analysis works. You don't pretend certainty. You map scenarios. Scenario 1. Pence is the turning point. The jury hears Pence, hears the recording, sees the pattern of pressure, and concludes intent is proven. Conviction becomes plausible. Scenario 2. Pence is damaging, but not decisive. The jury believes Pence, but still struggles with broader questions of belief, advice of counsel, and political chaos. You end up with mixed verdicts. Some counts, not all. Scenario 3. The defense successfully muddies credibility. They don't prove Pence lied. They don't need to. They just need to make 1 or 2 jurors say, "I'm not sure." That's enough for a hung jury on major counts. But here's the uncomfortable truth for Trump's defense. If you have to rely on muddying Pence rather than defeating the evidence, you're already on the back foot. Because juries tend to remember 2 things: a witness who seems steady and a defendant's own voice. And if Trump's voice is on tape saying, "I am begging you," jurors won't forget that. Now let's zoom out, because the Pence factor isn't just evidence. It's a narrative collapse. For years, Trump's defense to the public has been, "Everyone around me agreed. Everyone said I could. Everyone supported it." But Pence is the symbol of no. He's the one person who was in the exact position Trump needed and refused. So when Pence testifies, what he's really saying is, "I was there. I heard it, and I refused because it was wrong." That undercuts a major rhetorical shield, and it also puts a spotlight on something else: the motive for the pressure. If the vice president clearly didn't have the power, why pressure him? There's only one reason: because creating a crisis was the point. Delay was the point. Confusion was the point. And in obstruction cases, creating confusion can itself be part of the plan. Now, I want you to understand something very clearly. Even if Trump believed the election was stolen, that belief does not authorize a vice president to invent a power the Constitution does not grant. The prosecution will argue, you can contest, you can litigate, you can speak, you can rally, but you cannot obstruct a constitutional proceeding by coercing an official to violate his duty. And the recording, if admitted, would support that argument in Trump's own language. Now let's talk about why the prosecution would play that recording today, assuming it happened as described. They're not doing it for entertainment. They're doing it to lock in testimony. When you have a witness under oath and you play an audio recording, you're forcing the witness to respond in a way that can't be easily walked back later. You're building consistency. You're building a timeline. You're building a foundation for trial. So if Pence confirmed the call, confirmed the date, confirmed the words, and confirmed the pressure campaign, Then prosecutors just upgraded their case from "we believe" to "we can prove." And in a courtroom, prove beats believe. Now, what happens next is the part most people ignore because it's less dramatic but more important. After today, there will be motions, there will be hearings, there will be arguments over privilege, scope, admissibility, authentication. And the judge will make rulings that determine whether the jury hears this. But even before trial, the signal has already been sent. The government believes it has the inner circle witness, and it believes it has the audio. Now, one last point, because this is where reality bites. If Pence's testimony is as complete and detailed as prosecutors say, and if the recording exists, Trump's best legal move is not rage, it's precision. But rage is what he does. And rage doesn't rebut evidence. It amplifies it. The more he attacks Pence, the more he reminds the jury that Pence was close enough to matter. So here is what we can say responsibly, based on the framework we're seeing. A former vice president entered a federal courthouse and spent over 4 hours giving testimony in a case tied to January 6th. Prosecutors signaled that the testimony was substantial, and accounts circulating describe a recording in which Trump directly pressures Pence to stop certification. If those elements hold up in court, then today may be remembered as the day the story stopped being what the public thinks happened and became what a jury can hear happened. And those are two very different worlds, because public opinion is loud, but juries are quiet, and they decide with evidence. So the question now is not whether this is politically explosive. It is. The question is whether it is legally durable. Can the testimony withstand cross-examination? Can the recording withstand authentication challenges? Can prosecutors connect this intent evidence to the statutory elements beyond a reasonable doubt? If the answer is yes, then today wasn't just a headline, it was a structural crack in Trump's defense. And if the answer is no, if it gets excluded, limited, or undermined, then it becomes a warning sign about how fragile even dramatic evidence can be under courtroom rules. Either way, this is the next phase of the case. Not speculation, not vibes. Evidence, admissibility, and intent. And the next time you hear someone say, "This is all politics," remember this. Politics is what you say on a stage. Court is what you can prove with a record. And today, the record got heavier. Stay focused on what a jury will actually hear. Because that, not Twitter, not rallies, not outrage, is where this ends.